Good morning. Welcome to our discussion about challenging wrongful convictions of women. My name is Marissa Bluestein. I am an assistant director at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Carey Law School. And first, we want to thank the Innocence Network, Kate Murray, for inviting us on to talk about this topic, which we at least think gets really underrepresented in issues of discussions about wrongful convictions, how they happen, and how we can ameliorate the issues. So the background for this discussion is that we, the three of us, Sunny Eaton, who's with the Conviction Integrity Unit in Davidson County, Tennessee, and Valina Beatty, who is a professor at the Arizona State University, did a panel for the Institute for Innovations in Prosecution on the wrongful convictions of women. And the topic was so really robust for us as a discussion that when the opportunity came to present this to the Innocence Network, thankfully, Professor Beatty jumped on it and called us back together to do the discussion. So what we're going to be talking about today is this unique issue of what is different about women who are convicted of crimes they did not commit or crimes that did not happen. And where are the areas for reform? How are prosecutorial offices looking at this? How should innocence lawyers be looking at this? And what is the role for people who are not lawyers, who are not professionals in this field? Where's the role for them to play as well? So I want to start, though, with a brief introduction for my fellow panelists. Of course, Professor Valina Beatty is a professor of law and deputy director for the Academy of Justice at the Sandra Day O'Connor School of Law, Arizona State University, and also a cross professor of law in the School of Criminology and Criminal Justice. Valina got her start as a federal prosecutor and then served with served with distinction as an innocence litigator in Mississippi and West Virginia before moving to Arizona. Her latest book is Manifesting Justice: Wrongly Convicted Women Reclaim Their Rights. And as I said, Valina is the one who brought us together today. Sunny Eaton is also with us, of course. Sunny is the director of the Conviction Integrity Unit in Davidson County, Tennessee, located in Nashville. Before taking that position, though, Sunny was a criminal defense lawyer for her career, starting as a public defender and then opening her own firm. Her unit has become a regional leader in discussing wrongful convictions and promoting policies for prosecutors to prevent them from occurring, and even what is the role of the prosecutor in examining wrongful convictions. So Valina, Sunny, it's always great to see you guys. I want to start off with some data. And whenever we're looking for data in this field, of course, we go to the National Registry of Exonerations. They're the nation's leading expert, of course, on numbers behind wrongful convictions, about what they mean, what factors go into them. And for our purposes today, at least, they also are tracking issues of gender, of the differentials between men and women in convictions. And that's where I want to start off. So if we look at the National Registry data itself, starting with the numbers, what makes wrongful convictions for women such a unique issue? Well, we know from the National Registry of Exonerations, as you can see from these numbers, there are, from this slide, 3,216 exonerations. Of those exonerations, 2,955 were men, 280 are women. And that's in and of itself a very interesting number, and we're going to kind of get through that. But one thing that really I was very curious about from my own work as an innocence lawyer, is my gut feeling was that when you put those numbers apart a little bit, the numbers for women in terms of being convicted of crimes they didn't commit versus cases where there was no crime at all would be different for women than they were for men. And the numbers play that out. So the first other chart you're seeing here is where there was no crime committed. So these are generally cases involving arson, or what we used to call shaken baby syndrome, now sometimes referred to as abusive head trauma, even drug cases, where there was no crime, where the fire occurred because of an accident or really an unspecified source, but not deliberately set. Or in the cases of shaken baby syndrome, abusive head trauma, a child died or was injured through no fault of the caretaker. It wasn't through shaking or abuse, but because of some pre-existing condition, which then underlaid the injury and then came apart. So we know that those numbers are a little bit different from exoneration. So when looking at those numbers, again, based on this data from the 3,216 exonerations, 1,322 are cases involving no crime at all. When you look at those numbers in the scale of men versus women, of the 1,322 cases, 1,117 are men, 205 are women. So again, looking at those numbers by total exonerations from men to women, men are 92% of the exonerations overall. Women are the other remaining 8%. But when you break down the crime, no crime data, the crimes of the data of the 1,322 is only about 41% of the exonerations overall. So it's a smaller subset. Looking at that, again, here's the total number, same number you just saw of crime versus no crime. 41% of all exonerations are no crime. But when you bring in for women, look how that pie kind of flips. For total exonerations of women, 73% of those cases are no crime cases. 73%. So for a male who's going through the criminal legal system through an exoneration, the no crime incident is much, much lower. But for women, it's almost 3/4 of the cases involve cases where there was no crime at all. Looking at those no crime statistics overall, the no crime exonerations, men account for 84% and women are the other 16. But again, looking at for women themselves, it's 73% of those cases are no crimes versus only a smattering of cases which were actual crimes. So again, just kind of looking at this data from women in exonerations, from total exonerations of 3,216, women were only 8% of those. Where there were no crime committed, it was 1,322 cases overall, 42% of the overall number. Of those, women made up 84% of that group. And among women exonerees, whereas the total number of exonerations is 280, the no crime numbers is 73%. And that's what we want to kind of get to today. Vince, thank you. I'm done with the slides. With kind of diving into those numbers, why? What is so different about women? Why are they so overrepresented in these non-crime cases? And how can we start to address that from the criminal legal system? And I'm going to ask Felina to kind of step up first and talk to us a little bit about your work. You've obviously written a book on women exonerees and what is different about them and why this gender disparity. So I'm going to ask Felina to kind of step up first and take us through that. And then I'm going to ask Sunny to join us for the discussion about some cases she has worked on from the district attorney's office and her perspective from that. So Felina?
Great. Thank you, Marissa. And I'm just very happy to be here today. And I did pull together a little PowerPoint and just making sure everyone can see this.
You are good to go.
Great. So I did write a book that came out this summer, Manifesting Justice, about wrongly convicted women and how to advocate for wrongly convicted women in particular and for queer people as well. I myself, I initially was a prosecutor, as Marissa said. I was an innocence litigator for many years. I continue to represent a few clients, and I'm also a queer woman. So this really, I had a particular interest in diving into this, in writing this book. And the book focuses on two women, one of whom was my client, Lee Stubbs and Tammy Vance, who were wrongly convicted in Mississippi because they were women and because of their sexual orientation as well. And that, 10 years ago, that's what started opening up this question for me of how are women differently at risk of being wrongly convicted. Now, since the innocence movement started, really, we've seen this rapid growth in the number of women who are incarcerated. And you can see on this chart how much has happened just in the past 2 to 3 decades. So it is an important area for all of us to be aware of, discussing, and advocating about. Women's state prison populations, for example, have grown faster than men's and rapidly faster. So we have a large population there, which also means we have a population of women who are wrongfully convicted. And then in the juvenile system, sexual minority girls, queer girls, are disproportionately incarcerated as well. They're also at risk of being victimized by their peers. And to look at the intersectionality, BIPOC transgender people have high lifetime rates of incarceration. Black trans women in particular, nearly half of Black trans women have experienced incarceration in their lifetimes. Elizabeth Webster and Jody Miller, two scholars, they have done some great research on this and found that straight white women are often convicted for domestic crime scenarios, so child death cases, and cases that really hinge on these narratives of mothering, caretaking, being a bad mother, for example. And then, as Marissa pointed out, also involvement with a man who committed a crime, which are often drug offenses. Why? One reason is false confessions, is this internalized blame that women take on, even if there is no wrongdoing. This obligation to take responsibility, to apologize, to say, I'm so sorry, or to take responsibility for something going wrong, even if you didn't cause it, because you are the mother, because you are the caretaker, and because you are stepping up for that. So Amanda Knox herself, who will be in this program later today, she said, women are raised under a different social incentive structure than men, where attitudes of compliance, deference to authority are more encouraged. And this finds its most damning realization in the interrogation room, a situation designed to amplify the absolute control and authority of investigators, an experience I know only too well. So all of those pressures to take responsibility culminate in that interrogation room, where there's intense pressure and frankly manipulation by police to get some sort of a confession. And then another reason why, as Marissa also pointed out, is faulty forensic evidence, junk science. And I do want to just point out Tasha Mercedes Shelby, who was wrongly convicted in Mississippi. She continues to be incarcerated. She is my client, and she's been incarcerated based on the flawed diagnosis of shaken baby syndrome. We're currently in federal court, but like the cases Marissa was referencing, the child tragically died because of natural conditions that he had, not because he was shaken or abused.
And Velina, I'm sorry to interrupt, but there's a question from the chat about defining no crimes. Is that what you mean by a no crime situation?
Yes, it is. And I'm just about to get there. I love that question. Great. So no crime, wrongful convictions. Here's an example of Amy Wilkerson, also in Mississippi, where there was this coercion for her to falsely confess and then coercion to plead guilty for a crime that never happened, which was a child death. So no crime, wrongful convictions means the defendant was charged and convicted of a crime, but the crime never occurred. So the child, there's an allegation that the child died from abuse, but the child was not abused. The child died from an accident, like a shortfall, or from natural causes, like having a seizure. There is no crime there. But the allegation and the conviction is that this woman abused the child and caused the child's death. Marissa also gave an excellent example of fire science, of arson, where the allegation is that the woman set the fire, but actually the fire was caused by a faulty electrical outlet, for example. And Jessica Henry has written a great book on this called Smoke But No Fire that just exclusively focuses on no crime, wrongful convictions. And then, as Marissa showed us, National Registry of Exonerations data, I won't spend time on this, except nearly 3/4 of women exonerees were exonerated in these no crime, wrongful convictions. Okay, what's the takeaway here? This means women are less likely to have DNA evidence to exonerate them. DNA evidence, our gold ticket standard, that's what's going to get you out. Women are less likely to have that because there's no DNA pointing to someone else committing the crime. There is no crime. So you can't say, oh, it wasn't Valina, it was Sunny. No, there was no crime. So that makes these cases very difficult to litigate. And I'm going to also briefly talk about queer women and wrongful convictions and how they're particularly susceptible to wrongful convictions. And that's through stereotypes of being dangerous, of being deviant. And these stereotypes influence policing as well as punishing people who are queer or not acceptably gendered. So people who by their appearance appear not acceptably gendered. We have a long history in our country of psychiatrists historically labeling queer people as mentally ill. And by the way, queer is a reclaimed term for everyone who's under this umbrella. It's not a derogatory term, just FYI. And then there also was this strong fictional bond between being a lesbian and being a female psychopath. So we have this history going on here and these stereotypes of danger, violence, sexual predation, that sexual deviance means sexual violence. And here's just another reference if you're interested at the book Queer Injustice. So in my book, I'm talking about how Lee and Tammy, these two women who were lesbians in Mississippi, were wrongly convicted. And it was this combination of the faulty forensic evidence that we've been talking about and of homophobia. I'm just going to walk us through a little bit of the testimony in their case. So this was expert testimony presented by the prosecution expert about it's an alleged homosexual sexual assault. So in this case, you'd expect to find bite marks. If you haven't heard it, bite marks are extremely, extremely unreliable. I would say bogus. And should not be relied on at all. But they were to convict these two women. No, it wouldn't be unusual to find these bite marks. In fact, it would be almost expected. Almost. So this dentist claimed that the victim's genitals had been bitten off because of sexual orientation. And first of all, that allegation is false about her labia being bitten off, but also the connection to the sexual orientation is also just made up. But then we have a defense expert who says, would you expect to find biting in a lesbian rape situation? Yes, homosexual crimes are very sadistic. The more violent crimes I've seen are homosexual to homosexual. They do overkill, tremendous damage. And this man has no idea what he's talking about in terms of violence rates and homosexuals, but this is what he's saying. They're more gory, they're more repulsive than I've ever seen. So then the prosecutor in his closing says, okay, we've got the bite marks, and we know that these two women are lesbians. This all indicates a homosexual assault. It's them. And so the jury, considering all that evidence together, convicted these two women. And a more well-known example of a no-crime wrongful conviction of queer women and queer Latino women is the San Antonio Four. So they also had allegations of sexual abuse against them that were connected to the satanic ritual panic, that they were satanic abuse charges. Again, there's faulty forensic evidence here as well as the homophobia. So finally, solutions, and I think we'll talk about this more in our conversation this hour, more reliable forensic evidence. Melissa Lucio, she's a prime example of faulty forensic evidence. She's on death row in Texas, and of that pressure as a woman to confess. So to give a false confession when she's in the interrogation room. She was repeatedly berated to give a confession, and she ultimately did. We do have junk science writs in Texas and California, where claims can be brought based on this science is no longer reliable. And just last week, the governor of California signed a bill that really allows people in post-conviction to bring claims about expert testimony and forensics and unreliable expert testimony. So that just happened. We're on a roll with that. And another solution, briefly, is looking at these petitions and looking at all of the claims together. So legally, claims are dismissed individually as harmless error. And again, women aren't going to have that DNA evidence. So that means innocent women and queer people can't be freed if they don't meet the court's vision of what factual innocence is. So instead, courts can look at, in certain states, look at the entire case, look at all the claims together. So look at the gender bias, look at the homophobia, look at the racism in connection with the faulty forensic evidence, the false confession, looking at all of it together as a miscarriage of justice. And I'll leave us with one final story, which is Frances Choi in Massachusetts, who, when she was a senior in high school, she lost her parents to a house fire. So she was homeless, she was an orphan, police picked her up, and they saw her as the perpetrator, as the person who started this fire. And she went to trial 3 times. First 2 times hung jury, and the 3rd time she was convicted. And her attorneys were able to bring this miscarriage of justice claim to look at everything together. So to look at the faulty fire science evidence, to look at the prosecutorial misconduct, to look at the race and gender discrimination against her. And in 2020, a Massachusetts judge reversed her conviction based on all of this together, a confluence of errors, and a risk of a miscarriage of justice. And I'll end with this quote from Sharon Beckman, who directs the Boston College Innocence Project. It's clear to me that how Choi was wrongly convicted was a combination of racism, race and gender stereotypes, and a complete dehumanization of Choi. It's clear that an essential ingredient of the wrongful convictions of women is to dehumanize them. And that is all I have. Thank you, Vince, for helping me with the slides.
Thank you, Melina. Sunny, I want to turn to you. You have a different perspective on this, obviously coming from a conviction integrity unit who is charged with looking for wrongful convictions. And you're one of the few units in the country that has worked on a case involving a woman and been able to secure her release from a wrongful conviction. And just for folks who are watching who may not know, by conviction integrity unit, we're meaning a unit, a particular unit within a prosecutor's office that is tasked with looking for wrongful convictions. Some units define that as, quote, actual innocence. Some have a more broader perspective of that, but involves a reinvestigation. And Sunny, you've obviously been involved with that now for a couple of years. I turn to you.
Good morning, everybody. Yeah, my name is Sunny Eden. I'm the director of the Conviction Review Unit for the Nashville District Attorney's Office. I've been in that role for about 2.5 years. And prior to that, the majority of my career has been in criminal defense. This was an uncomfortable role for me to take on. It's not one that I anticipated, but when it was presented to me, what this is, what we're doing, what people are doing nationwide, this is not the kind of thing that as a defense lawyer who wants to make real change, you say no to. And it has been one of the most rewarding things of my life. The case that Marissa is referring to, many of you may be familiar with. It got national attention recently. It is a difficult case to talk about briefly, but I will do my best. The defendants in that case's name were Joyce Watkins and Charlie Dunn. This was a case brought to us by the Tennessee Innocence Project, which is frankly an incredible organization. We work very closely with them. Their advocacy it's top line advocacy. And that certainly makes my job much easier. They brought this case to us. Joyce Watkins, who is primarily who I'm going to talk to about today because we're talking about women, but she was one of 2 co-defendants, she and a man named Charlie Dunn. They both served 27 years. Joyce served the entirety of her sentence and then continued to advocate for herself after her release. Charlie, unfortunately, was granted parole, but passed away in prison prior to his release. What they were convicted of essentially was the brutal rape and murder of a 4-year-old child. Neither of them had criminal records of any kind before their arrest for this case, it's significant. They were in their 40s. This was Nashville, Tennessee. This was the 80s. These were 2 Black defendants. And frankly, to not have touched the criminal justice system in any way with all of these factors is quite the feat. They both had excellent jobs. They worked in a factory, often long shifts. Joyce owned her own home. She was in the middle of trying to adopt a child herself. She had gotten so far into that process that she had already prepared and decorated a room for the child that she had planned on adopting when this happened. Essentially, what took place was that Joyce had a 4-year-old niece who lived in Georgia with her mother, but was spending a few weeks during the summer with an aunt, Joyce's sister, in Fort Campbell, Kentucky, not too far from Nashville, Tennessee. If you're not familiar, it's about a 45-minute drive between the 2 places. The 4-year-old child had spent several weeks with the aunt. And in this particular week where everything happens, the aunt had called Joyce and had asked her to please come get the child. She said the child was out of control. She could not handle her. At first, Joyce declined. She was working multiple double shifts that week. She and Charlie, who she had been dating for some time, had a vacation planned for later on that week. But as the week went on, the phone calls became more urgent. They became more insistent. They became more aggressive. And finally, Joyce relented, and she and Charlie discussed it and said they could go late after they got off work. They had worked a couple of long days. They would go to Fort Campbell, pick up the child, and the next day arrange to meet with the child's mother in Georgia on the way out for their vacation. In total, this child was in the custody of Joyce and Charlie for less than 12 hours. I think we've estimated close to about 9 hours. During that period of time, the child's health considerably declined. They both noticed some issues even on the drive from Fort Campbell to Clarksville. At one point, Charlie referred to the child as seeming weak. They both reported that the child kept asking for water on the way home. And in fact, and police were able to confirm this, they stopped at a convenience store to get the child water on the way home. Now, phone records also showed that there was nothing unusual about the time that it took for them to get from Fort Campbell to Nashville. It was exactly the time period that you would expect, going normal speeds and all of those things. When they get home, it's fairly late. And there's some confusion about the time, but phone records show us it was probably around 1 a.m. that they got home. When they got home, Joyce takes the child to the bathroom and notices a small amount of blood in her underwear. At that point, she calls the child's family members in Georgia, her grandmother, her mother, and basically says, "What do you want us to do? And, I'm not sure the level of severity. I would like to take her to a hospital. Can you give me insurance information? What would you like us to do?" And what Joyce is advised at that point is actually don't do anything. We're going to drive there. We'll just see about the child ourselves. We'll come get her. By the time you even get seen in an emergency room, we could probably get there. Well, the next morning comes and no one has arrived yet. And the child's health has considerably declined. And it has declined to the point that what neighbors reported and what Joyce herself reported is the last action that Joyce really took with this child was running out of her home with the child in her arms into her car to rush her to the emergency room. There was increased blood. By the time she gets to the emergency room with the child is unconscious and slips into a coma. And later that same day, after treatment at 2 different hospital emergency rooms, is declared dead. The initial emergency room physician, who was just that, an emergency room physician, noted extreme vaginal tearing, head trauma, and estimated that the injuries that this child had been exposed to happened within 24 to 72 hours of presentation at the hospital. Later, the medical examiner shortened that time period to 24 hours, and 20 minutes before trial shortened that time period again to within 12. For Joyce and Charlie, these time differences made the difference between their innocence and guilt in the eyes of a jury, and certainly in the eyes of the district attorney's office that was prosecuting them. Other factors that were involved here, the investigation portion of Fort Campbell was very quickly shut down and ended by Fort Campbell investigators. And we have a jurisdictional problem here. This really left the Nashville Police Department unable to investigate really anything that may have happened at Fort Campbell with this child prior to her getting into the custody of Joyce and Charlie. Now, what we found out later, and certainly what we found even more through our investigation, were numerous reports and pages of reports that had not been available 30 years ago. One of those reports, which we were aware of but didn't have the entirety of, indicated that a DCS visit had even happened at the aunt's home in Fort Campbell because other people had noticed extreme behavioral problems and possible medical problems. The child had complained of pain going into the bathtub. The child was withdrawn, not playing appropriately with other children, was drinking out of toilet water, had actually gone unconscious 2 separate times and not been given medical attention or help during these weeks period of time. But despite all of these things happening, despite these weeks of incredibly serious and unusual behaviors and medical issues with this child, the investigation focused almost entirely on the less than 12 hours that she was within Joyce and Charlie's custody. I should note that the DCS worker who came to the house and wrote a report saying that there was no evidence of abuse never actually saw the child or spoke with her. In fact, the aunt told the DCS worker that the child had already been returned to her mother in Georgia, which was not true. And I'm making no statements about that, by the way, or indicators of anything other than, frankly, right, wrong, guilt, innocent. There are a lot of reasons that a Black family in the 80s might want to distance DCS from anything having to do with the child, particularly not one belonging to them. So I'm not making any statements there about the aunt. But it was an inadequate investigation entirely, to non-existent, which brings us to Nashville. So what happens here first, and when we talk about these cases, this case is a perfect example of it. It's never one reason. Valena and Marissa both touched on that. There are all of these factors that we know, but it is rarely just 1 or 2 of them that comes into play. It's generally a perfect storm of a multitude of factors. And sometimes we know those factors. Sometimes it's misconduct. And misconduct is not always intentional, and it's not always sinister. It's not always bad people doing bad things to get bad results. Sometimes misconduct can be mistake. It can be negligence. It can simply be biases that are at work. And I don't just mean the obvious ones that we know about: racial bias, sexual orientation bias. I mean the less obvious ones, including the bias that is created with the weight that is put on prosecutors' shoulders. I mean, the district attorney in this case has a 4-year-old child who he believes has been killed in a brutal way, and he has medical experts telling him it happened within this period of time. And he's responsible at that point for seeking justice for this child and for this family. And if you believe that these 2 people, Joyce and Charlie, did this in such a short period of time, then you would also believe to some degree that they are monsters. And if you believe 2 people are monsters, then dehumanizing them becomes a very normal way of looking at a case, handling a case, and sending a case to a jury. Now, for Joyce, there were some other factors that led to her as a suspect, some of which may not have even happened at all. There were many statements. Joyce and Charlie met multiple times without the assistance of counsel with police. They submitted to many interrogations. They welcomed police into their home to search their home. Now, there are many reports, and this became a pertinent issue at trial, and I think it also plays in when we're talking about gender. There were police reports that stated that Joyce had told them that she had washed the sheets from all of the beds prior to taking the child to the emergency room. Now, what we know 30 years later, looking at these reports, and certainly what was available but not really dealt with well at trial, was that these reports, these statements that police recorded, police did not write down notes for these statements until 1 year after these supposed interviews and statements were made, and only days before trial in preparation. And then lo and behold, they report very similar things. Now, if you ask Joyce to this day, she's always been consistent that that's just not true, that she never actually said that she had washed those sheets. Well, what we found 30 years later was a report from a social worker who visited the scene during a search warrant. And in that report, she actually notes seeing dirty sheets on the floor in the laundry room, unwashed. Police made similar notes. No one collected them. No one saw anything unusual about them. There are photos of these sheets, unwashed. There is no reason to believe that Joyce washed sheets prior to taking the child to the emergency room. But what is pertinent about that is Charlie was also staying in this home. And this did not become a particular line of inquiry for him. In some ways, it was this, not only is there a question about whether this even took place or anyone said it, but also this criminalization of this domestic activity was only used in a way to make Joyce's actions seem sinister. It really wasn't used with Charlie. You know, the question about this case as it relates to gender and what we learned, what became very clear to me, and what was a little surprising even in the investigation of this case, I have a small team. And at this time, this was sort of an all hands on deck case for us. This was a case that my instincts were very strong about from the moment of presentation. But we have to do all of these things, and we have to protect our investigations from biases. When we talk about women in particular, it is a different set of biases. We are very locked into the roles that we believe women play. And even more than I think we do with experts. Now, in the legal community, you know, we talk a lot about a reasonable person. What would a reasonable doctor have done or think? What would a reasonable lawyer have done or think? With women, we do that as well. We ask, what would a reasonable caretaker have done? What would a reasonable mother have done? What would a reasonable sister or a wife have done? Rather than asking, what did this person do? And was it reasonable given these circumstances? Which is a very different question, because we bring all of our own life experiences to the table when we view evidence. That is the lens that we view evidence, is through our life experiences. And with Joyce, this is one example that really surprised me. I mean, frankly, our team had many late into the night arguments and discussions, and many tears were shed during this case. But there was one small issue that really illustrates how bias plays in even to these investigations and the way that we look at these cases. So 2 members of my team are mothers of small children, of toddlers. And this case was very difficult for them. This was just a very difficult case, frankly, for mothers to look at. But one issue that one of the members of my team, a brilliant attorney who was a federal public defender, a death penalty attorney for many years of her career, could not get past the fact that a mother would send a toddler to another family member for several weeks and have very little contact. In her mind, we had to answer the question why. There had to be something going on with that mother in this other state that was somehow related to this story in Tennessee and Kentucky. And until we could figure out that question, she just could not get past it. It was a personal bias, because she as a mother could not see herself doing that with that toddler. Now, for me, there was nothing abnormal about this. I have a Puerto Rican family. We're all pretty close. And frankly, every single summer, I have a million cousins. We'd all get loaded up to whichever family member would take us on for the summer. And that's how we would spend our summers. And there was nothing about that that was unusual to me. When we step back and we look at the number of hours that discussion took up of our investigation, it really shows you how we bring these personal biases to the table. And when we look at Joyce's case, I should note that there was nothing connecting Joyce to any of these child's injuries. Nothing. Her crime was presence. It was caretaking. It was simply caretaking during this time period that these 2 medical experts put forth, and nothing else. And I think that while we do see this sort of presence guilt, we don't see it for men nearly as much as we see it for women, because of this caretaking idea. If we cannot come up with another reason, if we can't come up with direct evidence or direct understanding of what happened, well, you were in charge of this child's safety. And that is enough. The fact that something happened, possibly while in your care, becomes the default position for guilt in a way for women that we just simply don't see for men. Also, I want to take this opportunity really quickly before I forget to address one of the questions in the chat related to applications. You know, Joyce herself was unique in that even after her release, she continued to advocate for herself. And she did try to advocate for herself a lot among the challenges in prison. But as a CRU director who sees I probably get 20 to 25 new applications per month. Very few of these are from women. It's something, frankly, that keeps me up at night. It's a problem that I'm working very hard to address, because I just don't believe that there aren't women in the state of Tennessee who are claiming innocence and trying to advocate for themselves. But we've put a lot of thought into why that is. Why are we getting so few applications from women? And one thing that Valina talks about a lot in her book, and it really made an impact on me even in how I view this, is how much public pressure and support plays into these cases and what gets looked at and how they're looked at, and how the media tells their stories. And there is a reality for women that is becoming very clear. I get a ton of letters from wives, from mothers, from sisters, from girlfriends, from women working at nonprofits doing this work. Women advocate for men. They do it naturally. But what we're not seeing is the reverse of that. Frankly, I do not get many letters from husbands and fathers and brothers or men working in this field advocating for women. And I think it's like anything else. We have more men's prisons. We have more funding because we have more men in prison. We have more resources and more discussions. But for women, there is just less resources, less advocacy, less information getting to them. I also think that part of what we do to women women in prison in particular, is talk to them a lot about accepting what's happened to them and creating a life within prison rather than fighting what's happened to them. It's a very different perspective. And it is a problem that we have to actively address.
Thank you, Sunny. And Valina, I'm going to ask you to kind of jump on that question also. So we heard that from Sunny from the perspective of a CIU looking at these cases, but there's also the pulling on your experiences as running innocence organizations, what that looks like from a review. But I wanted to kind of throw in there first this notion that with women in particular, there are a very large subset of women who are convicted of crimes that they did commit, but which should have been excused of legal responsibility because of coercion, because of other domestic abuse, because they were battered women. And those issues either didn't get raised at the trial level or were disbelieved at the trial level. And I wonder if you could kind of touch on that from the perspective of someone coming from the innocent side of this, looking at cases and trying to find what's right.
Thank you. There are innocence projects like the Arizona Justice Project, as an example, in the state where I'm in, that do look at these cases of, is there a legal defense? Was there a problem here of this woman being abused for many years and acting in self-defense? There's a high-profile case that is getting a lot of publicity, and as Sunny mentioned, I think there's a lot of pushback on it because of the publicity in New York right now, where this woman, she killed her husband who was about to kill her. And it's actually, it's been so controversial that the prosecutor himself filed a motion for the case to be dismissed in the interest of justice. And the court denied it. And I've had that situation where I had a case where, again, it was someone who had committed the crime, but had this very, very strong legal defense. And the prosecutor agreed to dismissing the case post-conviction, and the court refused. So we have to look both at this power that prosecutors have and what's going on with judges as well. And in terms of the number of applications, it's the same thing as what Sunny said. We had so few applications from women at the West Virginia Innocence Project, at the Mississippi Innocence Project. And what really has opened up the door for me in the past is having one female client, because there's usually only one female prison in the state, which creates all these problems for trying to connect with your family members who could be 5 hours away. But having one female client who then would talk to other women and say, this is a possibility, to Sunny's point, like, you've always said that you're innocent. You can advocate for that. You can try to change things. And that's been the way to open that wedge on my end.
And I want to kind of follow that thread a little bit and then pivot toward solutions, right? Because I never like to have a panel that doesn't talk about the future and how do we kind of look at these things differently. But Sunny, I want to kind of just keep on this topic just a little bit. How do you respond to a hypothetical critic who might say that, well, women are underrepresented in the criminal legal system overall. So by specifically focusing on trying to find these cases, it's either unnecessary or counterproductive. How would you respond to that from a CIU's perspective?
You know, I really talk a lot about how important it is that we rehumanize everyone in our system, because dehumanizing is so easy to do. It's so easy to do on any part you play in how this is going. But I think that we have to look at this proportionally. This isn't about equality. It's not. This is about proportionality. I mean, it doesn't matter whether we have one woman wrongfully convicted and we have 50. Well, then we should be spending that same amount of time to make sure that we're solving this problem for women, and we have to do more to reach out. But, and I'm not sure if I'm actually getting to the heart of that question, but we have a responsibility. I mean, we did this, you know, and when I say we, I'm talking about district attorney's offices. I'm talking about state investigatory agencies, frankly. And when we talk about the perfect storm, I'm talking about everyone. I'm talking about the courts and lazy defense lawyers sometimes, or who just experts, all of us. We have a responsibility to undo this. We have a responsibility to undo this for every single person that this has happened to. So I'm not apologetic about looking a little deeper and trying to figure out how to get applications in for women who may have been wrongfully convicted, or spending more time on anyone who's unrepresented in this process. This is, I mean, that's what we're trying to do here, right? We are trying to right wrongs, and we're not looking at the numbers, we're looking at the people.
Thank you. And I do, like I said, want to kind of pivot toward some solutions for this. So Valina, there was a question in the chat about reliability of forensic science and evidence. You talk in your book a lot about how we can kind of move forward and try to address some of these issues from a systems perspective, with judges and prosecutors and defense counsel all playing a role. So, but starting on that issue of forensic science and kind of then moving toward the other individual stakeholders in the system, where do you see the areas for reform here?
Well, and innocence litigators have been working on making forensic science and forensic evidence more reliable, challenging it in courts for over 10 years. So there has been change. This has to happen on both the front end and the back end. So making sure that this faulty forensic evidence doesn't get into court. Bite mark evidence continues to be admitted in court. Why is that? Because in a criminal courtroom, it's usually the prosecutor who's putting forward the scientific evidence, and there's not the same vetting of it. So the prosecutor says, okay, I have this expert, and there's not what we call a Daubert hearing usually. There's not the same vetting. If we were in a civil case about money, both sides would have their experts and would be, you know, the battle between the experts. That doesn't happen in criminal cases. What I've seen in response to this is defense attorney offices that now will have, or it's a starting trend, now we'll have a point person who knows about forensic evidence, will keep up to date on forensic evidence. As we know, public defenders are overwhelmed with very high caseloads. But having a point person in the office who can say, hey, here's the problems with forensic evidence, especially the evidence in your case, here's a challenge that we can make to the evidence to make sure that this, again, bogus evidence doesn't come in, is crucial. So that's happening in public defenders' offices. I think there's greater awareness in prosecutors' offices. The reason we're not seeing as much bite mark evidence is because prosecutors are not bringing it in. So
well, I'm sorry.
Yeah, go ahead, Sunny.
If I can speak to that point, you know, I was talking about this recently with a group of young prosecutors in my office and a couple of others. And one of them asked me a really pertinent question. They said, you know, how am I supposed to know? How am I supposed to know whether what this expert is telling me is right? I'm not an expert, and I'm trying to rely on them. And that's not a simple answer. And I didn't have a simple answer for them. Frankly, I was really just pleased that they asked, because this is exactly the types of questions we want our young prosecutors asking. But we have to start training them that you are consulting experts to learn, not to prove. You are finding experts who can educate you about what your evidence is, and you should be looking to more than one. You are not looking to find an expert to prove whatever theory you've already formed and are trying to confirm it. And this is a baseline belief that we have to start combating early in the careers of prosecutors.
That's a great point, because one of the reasons these repeat player forensic experts have been able to testify repeatedly in cases and give evidence that is faulty in case after case after case is because of this reliance by prosecutors of, you know what, that expert always gets me the information I need, always gets me the win. So what you're saying, Sunny, is crucial. And I'll just point out one more thing, which is crime labs, most crime labs, only give their findings, their analyses to prosecutors. So there's a few labs that are now, they're saying it's scientific evidence. They're just giving their results to both sides. So the defense attorney can already have access to it. This is so important when we think of 95% of defendants pleading guilty. So having this information pre-plea is so important.
Right. And I think that kind of access to information is obviously critical. Being a little more skeptical, Sunny, as you're saying, and kind of promoting that as a value with prosecutors at the trial level is very helpful. And I think one of the ways to kind of build that skepticism, or at least maybe a more objective view, is kind of these, once a case has happened that you've reversed, like you did with Ms. Watkins, going back and looking at what happened in this case. How did it get here? How can we as a system modify to be able to prevent it from happening again? And so thinking again on Ms. Watkins' case, Sunny, back to you, if you don't mind, what did you learn from that in terms of the Davidson County District Attorney's Office? Have you suggested or implemented changes in policies and how you approach these cases, or done training, or what lessons are you taking away from that to prevent that kind of injustice from happening again?
Joyce's case it's a great one for that kind of information. It is. And now in our office, we strongly encourage all of the prosecutors to read our CRU reports when we do on this. We are very detailed at every step of the way. We try to address every single thing that went wrong. And in her case, not only was there an over-reliance early on, frankly, medical evidence that was never that reliable, but there was also a failure, in my mind, of the assistant district attorney to represent honestly to the court when it was very clear that the current medical expert was not presenting accurate information. I am still galled and affronted that a medical expert, the primary one by the state, was able to completely change course in her medical opinion 20 minutes before trial, and no one on either side asked for a mistrial. No one on either side thought, this is not a fair way to go forward, something is wrong here. And we both have a responsibility to that. And cases like this, especially, frankly, with Ms. Watkins, she is such a sympathetic individual. And not that any wrongfully convicted person is different than others, but some are just better for teaching in terms of really getting to those heartstrings that we've got to get to with our prosecutors. This is a perfect case to discuss with that. She had no criminal record. She's 74. There's all of these factors that make young prosecutors listen. But beyond just what got us to the court, to the trial, we also have to look at what led the assistant district attorney to present the case in the way that they did. And I think when we start talking with prosecutors about sort of what I was talking about earlier, the biases that are created simply from the weight of the case, the biases that are created from the role of the prosecutor and how that leads to the behaviors in front of a jury and in court and what's presented. There's a lot of education to be done there. I mean, in Joyce's case, there was racism in the closing arguments, and it's undeniable in my mind that that's what that was. We may not have identified it that way in the 80s, but its impact would have been the same, if not greater, because of our lack of awareness of what some of these dog whistles were. There was, in some ways, othering of Miss Watkins, which not only happens to women, but really happens to minority women, and a lack of willingness to holistically look at her as a person rather than this defendant charged with this crime. So these are the discussions we're having in my office. You know, my boss, who I consider an incredibly progressive, heavyweight thinker on these issues, has empowered me to go out and educate as much as possible. And I think that's what we have to do. We have to start talking about what went wrong and being able to use these very poignant examples.
And you kind of touched on something there that I'd like Valina's viewpoint on in the last few minutes that we have together, which is this issue of the gender imbalance in defense counsel and prosecutors. So when you look at the numbers, the prosecutors are majority male. I think it's about 65% of prosecutors nationwide are male. In criminal defense, private criminal defense bar, it's really almost 3/4 are male. I think from the latest numbers I was looking at, the public defenders are more evenly balanced. But Valina, do you see a correlation here, or either anecdotally or science-based, between the gender of the person representing people at trial and the outcomes of a wrongful conviction for women?
So I don't have concrete connections between that, but I do think that courtrooms continue to be very conservative, where even when you have women as litigators, there's still expectations that they present a certain way, that they look a certain way, and that if they don't, that can be transferred onto their client if they're a defense attorney, or onto their case if they're a prosecutor. You're right. I think it's a tremendous problem that prosecutors' offices are predominantly male, predominantly white, don't present with disabilities, all of these intersectional identities that then end up allowing stereotypes to flourish, stereotypes to be used against a defendant who is in the courtroom and is the only person who is a person of color, is the only person who is a woman, is the only person who is openly queer with a disability. So I truly think that having more diversity within the prosecutor's office will encourage more awareness of, okay, is racism a factor in this case? What's going on here? But B, will also help with how cases are prosecuted, and not saying, here's the one person who is a person of color, and we can put, as Sunny was saying, we can say this person is a monster, and we can tie racism or sexism into that.
Thank you. And we have about 3 minutes left, so I'll take a 30-second answer from each of you on this. What is the one thing or two things that you would recommend or like for non-practitioners in the audience to take away from our conversation, to put a positive spin on? Sunny?
I was with you until you said positive spin. I actually think it's very difficult, and I hate to bring this down to money, but it does come down to that. I mean, we've got to provide better funds for adequate defense. We have to put resources in DA's offices specifically for looking back at these things, because no matter all the prevention we do, all the education we do, I did a talk last week that was called "Everything's on Fire: Why We Will Never Stop Wrongfully Convicting People." Number one thing is we have to reckon with the fact that no matter what we do, this is always going to happen, because this is a human system. So we've got to fund innocence organizations, we've got to fund CRUs, we've got to better educate the public, and we've got to start pushing back on the media with some of the ways that they present this on all ends, so that we create safe spaces to fix these problems.
Great. Valina, your take on it?
Yeah, so my big takeaway is that people can be criminalized, they can be policed, they can be arrested, they can be prosecuted and convicted based on their identity. Okay, not because of a crime having occurred, but based on their identity and based on stereotypes. You've heard a lot of those examples today, particularly caretaking women. What can we do? I was really encouraged that this bill passed and was signed last week in California that says if you had an expert testify falsely at your trial, you can bring a claim. If you have faulty forensic evidence in your case, you can bring a claim. And to Sunny's point, we need to move away from this focus on just DNA. DNA is not going to help many women who are incarcerated. We can't just say, do you have the DNA to 100% prove that you're innocent? No. Is this conviction still valid? Look at all these things that went wrong. What about that? Instead of this hyper focus on DNA. And the last thing I'll say is court watching, going into the court, sitting in the court, watching what's going on at trial. It makes people act differently in the courtroom.
I could not agree with that more. And we are at time. So I just, again, want to thank you both so much, Sunny and Valina. I cannot express how much I always learn from talking with the two of you. So thank you. And thank you to the Innocence Network for having us today. Looking forward to the next panel coming up. Thank you, everyone.